bringing the appeals Dover District Council and CPRE and China Gateway Limited.
Good morning, Mr. Campbell. Good morning, my ladies and my lords. I appear for the first appellant, Dover District Council, together with my learned friend, Mr. Simons. Mr. Matthew Reed and Mr. Matthew Fraser appear for the appellant, China Gateway, and Mr. John Howell and Mr. Ned Westerway appear for the respondent. My lady, this case concerns a challenge by judicial review to the grant of planning permission by a local authority. And I turn first to the development proposed and to the description in the statement of facts and issues. And so can I take, ladies and your lordships, to Core Bundle 1, tab 5, and to paragraphs 3.2 and 3.3, which appear on page 140 in the electronic version, I hope.
Well, as usual, the electronic version is not working. And so I will have to take remedial action, but carry on speaking, Mr. Campbell. I can listen and do at the same time.
So, my lady, the second appellant, China Gateway, applied for planning permission for development on two separate sites. And in order to allow the court to appreciate that, if you have Core Bundle 2 also to hand and go to page 296, I hope. Also is numbered 290, but I'm told that 296 is the electronic version. Oh, well, it looks as though I may be on the
Is it a plan we're looking at?
It should be a plan like that.
Yes.
So it's 296, I think, on the electronic, 290 on the... That's the one. So, lady, this application for planning permission related to two separate sites. To the west, you see an area marked in blue, which is known as Farthinglow. And to the east on this plan is an area where there are two areas marked in blue, which is known as Western Heights. And Western Heights in Dover are the site of fortifications from various periods in history, and they provided a defence to Dover from the west. The docks are to the east. But the application, going back to paragraph 3.2 in the Statement of Facts, was for outline planning permission for the construction of 521 residential units and a 90 apartment retirement village on the land at Farthinglow. And the land at Farthinglow is divided into two parts known as FLC and FLB. I'll come on to that in a moment. So that was the bulk of the residential development, but it also proposed, there was an application for outline planning permission also for 31 residential units and a hotel and conference centre at Western Heights. The provision of pedestrian access and landscaping work between the two sites. And then there was an application for full planning permission, remembering that one can only have an outline planning permission for the erection of a building. so for full planning permission for conversion of certain buildings. But for the purposes of this case, I can, but I don't think I need to go into the details of that. But the conversion was of a building at Western Heights to provide 9 units, and for conversion of the existing farm buildings to various uses at Farthing Low. And if I could then turn to the planning permission itself.
Mr. Cameron,
Yes.
it wouldn't be possible to have a slightly bigger version of the plan at 296. I don't know whether one exists.
Well, I'm sure those behind me will listen to that and see whether we can assist on that.
It's quite difficult to read what it says. Yeah.
It is, my lord. We'll do what we can. It may be that we have to provide that after the lunch and adjournment. I'm just...
Yes, but if it's a problem, don't worry, but it would be helpful if it exists. Thank you.
If I can turn then to the decision notice, so the actual planning permission that was granted, and while we have core bundle 1, I can go to core bundle 1, tab 2, and to page 66 in the electronic version. So it's 66 and 67. And that is the decision notice which grants the planning permission. And I only turn to that because it shows the extent of the planning permission, an outline planning permission for the development I've already referred to, 521 residential units. They are at Farthing Low. 90 apartment retirement village, also at Farthing Low, and a health facility, all together at Farthing Low. And then at Western Heights, the 31 residential units, the hotel, and the pedestrian access to link the two. And then the full planning permission is for conversion of various buildings at Farthing Low, that's 1, 2, and 3, conversion of the Victoria Hall at Western Heights to provide 9 residential units, and then the works to the Drott Redoubt to create a museum and visitor centre. And the essence of this, an important factor that formed part of the proposal of this composite application was that the provision of residential accommodation at Farthing Low was to generate a financial surplus, and a sum of £5 million was to be paid to allow works to be carried out to restore part of the fortifications at Western Heights. Now, the lawfulness of that arrangement was in issue in the High Court. It is not in issue here. This appeal does not concern the lawfulness of that arrangement. But I set that as background because it explains the composite nature of the application and the relationship, part of the relationship between the two.
In the appeal to the Court of Appeal, something called Ground 1 was the subject of a refusal of permission. It might be helpful to know what is totally off limits to us by your telling us what Ground 1 was.
Well, my lord, Ground 1 was a challenge which was pursued in the High Court, and the argument was that it was not lawful for the council to take account of a financial contribution of £5 million towards works at Western Heights, and there is a provision known as Regulation 122 in the Community Infrastructure Levy Regulations, which provides that a planning obligation cannot be a reason for granting planning permission unless it's necessary to, I'm now trying to cite it correctly, but the essence of it, it has to be necessary to Mr.
Well, it doesn't really matter,
Yes,
does it?
I'm
Because
just-
it's not going to affect this appeal
No,
one little bit.
I'm hesitating because
Yes.
I don't want to give you the wrong words, but it has to be necessary
If it's
to
to
enable
do
the
with the
development.
£5 million, then
Yes,
that's enough, I think.
It goes
Yeah.
back to a case about Covent Garden, which I seem to remember.
It does.
Then there have been regulations.
It was simply my Lord was concerned that in dealing with what is before us, we don't trespass into something for which permission was not given
Quite.
to the Court of Appeal. You have reassured him on that, so we can
Thank
move
you.
on.
So I'll move on. Okay, So objections to this application were made by a number of parties, and those parties who objected to the grant of planning permission included the Campaign for the Protection of Rural England, who are the respondent here. And their objection is summarised in the officer's report to the Planning Committee. And I am going to spend a little time on the two reports made by planning officers to inform members who made the decision. But if I can turn then to Core Bundle 2, tab 911. This should start at page 360. And this is a report prepared by the planning officers of the council, which was before members when they made their first resolution in June 2013. It's a lengthy report, and I intend to spend, I hope not too much, but a little time on it. But if I can first just identify at page 387 the objection made by the CPRE. And the CPRE objection is summarised at page 387. The CPRE objected in particular to the development at Farthinglow being land which was not allocated for development and falling within an area of outstanding natural beauty. And they said at page 388, as summarised, the proposal will not comply with the National Planning Policy Framework, and this, together with its impact on the area of outstanding natural beauty, means that it does not comprise sustainable development as defined by the National Planning Policy Framework. The application, when it came before the members, was, as I have described it, including for 521 residential units at Farthinglow. And that land is identified in an appendix to the committee report, and one has to turn to page 525 to find a plan, which is slightly easier to read than the other plan. So it's, I think, 519 in paper, 525 electronic. This was an outline application, so that was an illustration of the development which could take place if the outline application were to be approved, and subsequently further details were submitted under what are known as reserved matters conditions, matters reserved for subsequent approval. So, my ladies and my lords, see FLB to the west and FLC to the east. And the total number of units proposed were 521. The it's important to note, while you have that plan to hand, that FLC had previously been used as a works compound, the Channel Tunnel, so it had had development on it. It had subsequently been cleared and returned to a grassed area, but there was an extant planning permission, a planning permission which had been implemented and could therefore be carried into effect for business class uses.
For built development.
Built development for business class uses, built development, B1, office and related uses.
And an outline planning permission.
My Lord, I think if I can just check
Don't
that.
worry now, it may not matter.
That is it's a full planning permission. It's referred to at page 412 in the report. It was a full planning permission for a business park at Farthinglow, and it had been implemented through the construction of an access road.
Which paragraph?
2.18 on page 412, my Lord.
Thank you. Yes.
So that was part of the planning history, but the officers then considered the likelihood of that development being carried out. The officers reported to members, and they made a recommendation, but their recommendation was not that planning permission should be granted for the full extent of the 521 units, but that, if I can turn to page, ask your ladies, my lords, to turn to page 494. Their recommendation was that outline planning permission be granted at Farthinglow for up to 365 residential units, not for the 521 which had been applied for. And they recommended to members that a particular area of land be, as they put it, safeguarded, so that development should not take place on it. And that area of land is shown on page 533. And that was Appendix 5 to the officer's report. So it was a recommendation in favour of granting planning permission, but not for the full extent of development for which the application had been made. And the reasons for that can be found if one turns back in the officer's report to page 447. And 447 and at paragraphs 2.215 and following, the officers explained their position. And they were addressing the planning policy considerations set out in paragraph 116 of the National Planning Policy Framework. And if, keeping perhaps a finger at page 447, if the court were to turn back to page 411, they would see the advice that was given to members on paragraphs 115 and 116 of the National Planning Policy Framework. And no doubt the court will be familiar with this, but when a planning authority is determining a planning application, it has to have regard to the development plan and to other material considerations. The National Planning Policy Framework falls into the category of an other material consideration. So the members had before them a reference to paragraph 115, referred to at 213, which states, amongst other things, that great weight should be given to conserving the qualities which justify designation of an area as an area of outstanding natural beauty, and to paragraph 116, which sets out criteria for assessing major development in an area of outstanding natural beauty, and there's no dispute that this fell into the category of major development in the area of outstanding natural beauty. And one of the factors, and this is 214 at page 411, I think I ought to read out 214 because it summarises paragraph 116, which lies at heart of this case, that planning permission should be refused for major developments in the area of outstanding natural beauty, except in exceptional circumstances and where it can be demonstrated that they are in the public interest. And then consideration of such applications should include an assessment of 3 particular factors. And it's the last factor with which the officers are concerned at 2215, and that is any detrimental effect on the environment, the landscape and recreational opportunities, and the extent to which that could be moderated. So turning back to page 447, the officers had formed the view that there would be harm caused to those aspects of the area of outstanding natural beauty, and they turned their mind to the criteria set out in paragraph 116. And at 2215, they address this point, and they say, achieving a design solution for this location would help moderate harm to the area of outstanding natural beauty and deliver a viable quality development is challenging. In view of the concerns relating to the deliverability and marketability of the indicative proposals, Smith's Gore, as part of the viability assessment, examined an alternative outcome. Now, Smith's Gore advised the council. They were viability advisors advising the council. Different advisors advised the applicant for planning permission. This suggested a more traditional lower density development at Farthinglow of around 375 dwelling houses. Smith's Gore concluded that this would be more marketable, financially viable, and could also afford the relevant monetary contributions and the £5 million heritage payment currently on offer. This would require a reduction in the Code for Sustainable Homes rating from Code 4 to Code 3, saving building costs of some £4,900 per average unit. The option was included in the information previously sent to the council by the applicant's viability advisor, BNP Paribas, which has not been challenged and was also subsequently brought to the attention of the applicant, although no comments have been received to date. That was at the time that the officer's report was written. And then in 2.2 216, a refinement of the above approach has since been carried out in liaison with Smith's Gore. This suggests that a viable scheme could be achieved with the removal of development from a 2-hectare part of FLB to the southwest, where officers consider the landscape harm caused by the current proposal is most acute. And then reference is made to the plan to which I've just drawn the court's attention, with the one with the safeguarded area marked on it. It's at page 533. And then they said that that's how they got to their 365 units, which comes in the recommendation. I won't read out 2.217, but I'd ask the court to have regard to it. And then
do we have anywhere an explanation of the CSH rating? I mean, I've had a look myself on Google.
We do, my lord, in terms of the effect it would have on the cost.
No, just what it is. I mean, it's a government rating standard for achieving better sustainability, is it, or something?
That's right. It's called Code for Sustainable Homes, and the higher the rating you have, the more energy efficient and environmentally sustainable the home is, but it costs you more to do it because you're paying for different materials and different means of construction.
The officers are suggesting that you could make some significant savings by reducing the standard but still attain an acceptable level. Is that the idea?
Yes, my lord, and the reason for that was that they explain in 2217 that a certain standard was contemplated at the time the plan was promoted.
Yeah.
The standard was changed, so even if you reduced it from 4 to 3, you ended up with, broadly, the standard and quality of environmental protection that you and sustainability that would have been achieved as contemplated at the time the plan was promoted. Yeah. But we do have here, and I can take your lordship to it, the figures, but in effect, if you reduce it from code 4 to code 3, you reduce the cost per unit.
And do we know where PNB Paribas stood on that? Or
Well,
what the members thought about it?
We do, my lord.
So you'll come to that.
That's what we're coming to in a moment.
Anyway, if there is somewhere a simple sort of 2-page statement of what the code is and what the significance of the differences is, there must be a government handout or something.
Yes, we can provide that.
Thank you.
And as I say, I can go to the maths, but I'm not sure that's what...
I'm not terribly interested in the maths.
So 2218 on page 448, that is dealing with moderation. The officers say the reduction in density and the setting back of the developable area, however, would represent a notable material moderation of the harm, both in terms of direct landscape impact and degree of urbanisation, the merits of which would need to be weighed with other policy considerations in this report. So that was their recommendation. And then if the court would turn on to page 492 and to paragraph 2.456 in the officer's report. The officers there contemplated that the changes that they were proposing would be opposed by the applicant for planning permission. And I seek to emphasise in the first sentence of the paragraph, its second line, it's very likely that the conditions changes proposed to the application in order to address some of the planning challenges will be opposed by CGI on the basis that some or all might put the project at risk. And they've been forewarned by the applicant. These are the points which they say they're concerned about. And they then go to 2.457. And to save time, I won't read that out, but towards the bottom, the last sentence, however, the officer's position is that the conditions or changes as set out in this report, informed by independent legal and financial viability advice, and I place stress on that, are well-founded and that all are necessary to deliver the right composite package, including the economic benefits, so that on balance, recommendation of approval can reasonably be made. So that was the officer's position. They recommended approval, but subject to those changes being made to the application. We then get...
would it have been, it would have required the changes to be made by the applicant. They couldn't have been imposed on the applicant, could they?
Well, the view that the council took was that they could be imposed on the applicant, applying in effect, the Wheatcroft principle that you can grant planning permission for something other than that which is applied for.
I see. And is that common ground? But as far as it's not an issue as far as
it's not an issue, my lord, and it didn't actually happen, so that is probably why it needn't have been. I say it didn't happen. The members did not accept the officer's recommendation.
No, anyway, it's not an issue we're being asked to consider.
No, my lord. But the view that the council took was that they were empowered to grant planning permission in that restricted form. I then turn to the minutes of the planning committee meeting, which are found at tab 912. And an oral report was presented by planning officers. And
sorry, where is this again?
Page 539.
539.
My lord. 539 and following. So these are the minutes of the meeting which was held in June 2013. And if I can go to page 540, and this is, in fact, I can go to the second paragraph, and this deals with my Lord Carnworth's point. The applicant argued that the change to the number of dwellings was so significant that it could not be carried out by the council without the approval of the applicant. The council had, however, received its own legal advice that it was possible to impose such conditions. So there was a point raised by CGI. But then the next paragraph, the third paragraph on the page, they're not numbered, on viability, so this is the officers reporting to the members.
I'm sorry, I've probably got the wrong page reference.
540, my lady.
540.
I'm now worried that
No, well, 540.
Yeah.
It begins on viability.
Well, the page starts the principal planner.
Yes, I find it now. That's fine.
On viability, the applicant's consultant, BNP Paribas, had stated since the report was written that they disagreed with the conclusions of the sensitivity analysis carried out by Smith's Gore, the council's advisors. In their view, a lower density scheme would turn a positive land value into a negative value. On this basis, it would not be able to secure the necessary funding. The viability of the scheme would be further undermined by the report's recommendation for graduated payments when a substantial upfront payment of £1 million had been offered. It was suggested that the density details outlined in the report did not fairly or accurately represent the applicant's proposals. The principal planner advised the committee that, having considered the further views of BNP Paribas, Smith Score stood by their analysis that a lower density scheme would be viable and would deliver the same monetary benefits as currently on offer. Officers therefore recommended that a lower density scheme should be approved as it was viable, not excessive for the site, and would be compliant with the core strategy. So the issue with which members were grappling was that they had conflicting advice. The applicant was saying that if the scheme was reduced as proposed by officers, it would put the financial viability of the scheme at risk, whereas the council's advisors were taking the contrary view. So that is what
Did they have enough information to decide between the two?
My Lord, they had sufficient information to decide on the essential issue, which was, would imposing these changes put the scheme at risk? And that was in my submission, was the issue that they had to determine. Now, I've referred to the minutes because your lordships may have seen that from the judgment of Lord Justice Laws in the Court of Appeal, there was an issue about whether the letter which had been written by BNP Paribas, which is summarised in these minutes, had actually been placed before members. And in the Court of Appeal, I took instructions on that matter, and my instructions are recorded in Lord Justice Law's judgment, which were that the letter, which, just for the court's note, is in the appendix part 2, tab 8, page 831. It's a letter of the 11th of June 2013. But my instructions were that this had been given to the chair of the committee, and that was the ambit of my instructions. So I, on that basis, do not rely on that letter having been placed before members. What I rely upon are the minutes which show the report which was given to members by officers.
So the position factually is, as far as we're concerned, is that there's been a verbal report to the committee of BNP Paribas' views and a verbal report by the officers of Smith Score's views and response. And that's the sum total of the information?
That is the sum total of the information as set out in the minute on page 540. Yes.
You're saying that's good enough?
My Lord, yes. I'm saying it's good enough to inform members, but in the context, because it's not only the decision on this application was not made solely in June 2013. This application was a resolution to approve in June 2013, subject to entering into a planning obligation and the like, and the matter was then taken back to members in December 2014, and there was a further report presented to members in December 2014.
But was this issue reopened and rediscussed?
The viability issue was not reopened. What the officers did was to remind members of the matters that were before them in June and the decision that they had taken in June. But I can come on to the detail which was put before them.
But Mr. Cameron, pressing you a little bit further, where you've got BNP Paribas saying, no, not viable, and Smith Score saying, yes, viable, without any further reasoning. How can anybody, whether it's a committee or indeed a court, but forget that, how can a committee decide between the two?
Well, what the committee were doing, my lord, were not making a decision, did they accept the assumptions made by one valuer or another, which is they were making a decision, were they willing to put this scheme at risk on financial viability grounds? That was the essence of their decision. So they didn't have to make a decision, did they accept one or another, but was there a sufficient risk to a scheme which they considered to be very important for Dover to be put at risk? And that, what they were being told by the applicant was there was a risk. So it wasn't just BNP Paribas say the numbers don't stack up, but the applicant for planning permission was saying that it would put the scheme in jeopardy.
But I mean, they're not entitled to accept the applicant's say-so on that, are they? You know, there's obviously the applicant had every reason to say, well, we want the full 500 odd units. And the committee have presumably got to look at that critically and say, well, are we persuaded that that's actually a sound objection?
But that, in essence, my lord, is a matter of judgment for them, whether they are...
What do we, I mean, one of the troubles here is that we haven't, you accept that there should have been a statement of reasons for the purpose of the EIA.
Yes.
And you're, in fact, asking us, in effect, to tell you to produce one. But what I don't understand is why has one not been produced in the 4 years since this was taken?
My lord, the reason one hasn't been produced is because if one was produced, it would be said to be an ex post facto justification.
Well, yes, but I mean, your point is you're entitled to it.
Yes.
I mean, your position is that you have a legal duty to produce one, but you fail to provide the public with such a document, and whether or not the other side are right about the effects of that, the least you could have done, I thought, was actually to comply with what you say is your duty.
Well, my lord, the view was taken. There was I fully accept there was an opportunity to produce one, particularly after the first instance judgment. But at the time, at that point, was not pressed by the...
It wasn't pressed by the CPRE. I mean, it would have been very useful for us to have seen how you would have formulated, or indeed how you would now formulate what you say is a critical point and your reasoning on it.
Well, my lord, we say that from the minutes and from the subsequent report, the reasoning is quite clear. And that is, so if a statement had been produced, it would have reflected that which is in the minutes and in the subsequent officer's report.
Mr. Cameron, to return to the risk that you identify, do you say that on the basis of the material at page 540, the decision makers were able to evaluate that risk, or do you say that it's enough that a risk had been identified?
The latter, my lord. It was enough that a risk had been identified, and that was a factor for them to take into account. I'd have to accept that they couldn't, without the detailed financial viability appraisals, it would be very difficult for them to identify the precise extent of the risk. But then these are members of a planning committee who are presented with an application which they consider is important for Dover, and they took the view that they wished to seize the opportunity. And they, in my submission, didn't have to carry out a detailed exercise of weighing the financial viability information provided by one advisor against the other. They were entitled to say, we've been told that there's a risk that the scheme is in jeopardy, and make a decision on that basis.
So you say that the say-so of BNP Paribas carried the day?
I do, for the reasons set out in the minutes. And the reasons set out in the minutes are on page 542, if I could turn on there. And these are the councillors speaking in favour of the proposals, and this is on the third paragraph on page 542. It comes after the second full paragraph where the head of inward investment was highlighting the benefits of the scheme. And I think I will read out the third paragraph because it is...
Why don't you let us read it?
Yes.
The one beginning councillors Cowan, Walkden and
Yes,
Walker. Yes.
my lady, thank you.
Yes, thank you.
And the emphasis I place, and it's in part an answer to my Lord's question, see that this could jeopardise the viability of the scheme, deter other developers, and be less effective in delivering the economic benefits. So it was those combination of
But
factors.
it's could rather than would, you say?
Well, those are the words, could. Yeah. It's a risk.
But can I just ask, take the discussion a bit wider, that all of this proceeds on the basis that there was a binary choice. It was either the full development or the modified development. But the planning officers in their report had said how finely balanced this was. There was another paragraph in which they set it out, and it was only the modification of the scheme that allowed them to recommend that it take place. So on their view of things, the viability of the modification was an essential feature. So there were three options on that analysis, the third being no development at all because of the harm to the area of outstanding natural beauty. So everybody on your side proceeds on the basis this is a binary choice. Why?
Well, my lady, there is obviously a third option of just refusing planning permission, but on the basis that the members and indeed the advisors, and in particular the head of inward investment, saw the scheme as providing benefits. Yes, there was the option of not having the benefits at all, but if one was to have the benefits, and in particular the regeneration benefits and the opportunity to begin the restoration at Western Heights, there were only two choices. But I accept, my lady, of course there was a third choice, just refuse planning permission.
Where do we see that reflected in the minutes?
The officers made their recommendation, and that was their role, to inform members. But on any it's reflected in the minutes, my lady, on page 543, in that one of the councillors is recorded as arguing that planning permission should be refused. So, and then there was a vote which offered members the opportunity to vote against the grant of planning permission. So to that extent, it is canvassed in the minutes.
That's Councillor Cronk.
My Lord, yes. Councillor Cronk was against granting planning permission. And he, or she, I don't quite know, but the councillor referred to the National Planning Policy Framework's public interest test, which had been drawn to the attention of members.
So how was the vote structured?
The page 543, my lady, it was proposed and just about 4 paragraphs up, it was proposed and duly seconded that recommendation 1A and 1B of the report be approved, subject to the amendment of A1 from 365 to 521 residential units, and on being put to the vote, the motion was carried. So it appears to have been rather than taking one vote on should it be amended and then another vote on whether permission be granted on that basis, it was a proposal that permission should be granted on the basis of 521 units.
Such a lot depends on how one structures a vote, doesn't it?
Well, it can do, my lady, but in this case, that was the decision taken by those elected to make these decisions. So that was the... And then there was a slight hiatus and the meeting resumed, and then the resolution that's passed, one can see on 544 and following. But, and just before we leave these minutes, at the part that the court read to itself on third paragraph on page 542, the members appeared to have had in mind that it wasn't just financial viability and jeopardising the viability of the scheme, but they did have in mind the impact on the area of outstanding natural beauty and the possibility of screening.
Well, they refer to it in that paragraph, but do they anywhere address the recommendations made by the officers in relation to the efficacy of screening?
Which is that it wouldn't be very effective.
Which is that it wouldn't be very effective.
Well, there's nothing in the minutes there, but when we get on to the December meeting, by that stage they had a planning obligation before them, which would have proposed some structural landscaping. So at that stage, it was addressed to that extent, but I can't point to a part in the minutes where they debate would it be effective or not. But all I can do is part of the minutes when seen from the ground, and with effective screening it was believed that this could be minimised. That's what is recorded in the minutes as to the members' view.
And more generally, do they anywhere address the assessment of the officers as to the harm?
They don't assess it, and my submission on that is they can be taken to have accepted the officer's assessment of the extent of the harm.
The officers observed that their assessment of the harm which would be inflicted by the development as proposed was, quote, a significant detrimental impact on the landscape and long-term irreversible harm to an AONB.
Yes, my lord. But then the members then have to make a judgment as to whether they would permit this major development in the area of outstanding natural beauty, applying the criteria set out in the policy. That's a matter for them.
Yes, I mean, that's your answer to what Justice Laws is concerned, that good or bad, they accepted the officers' various views on that issue.
Yes, and my lord, on the basis of ex parte Faber and other cases, members one can assume that members have accepted the analysis of officers in making their decisions unless they indicate otherwise. And here there's no indication that they departed from the officer's assessment of the extent of harm. But they were then entitled to make their decision. Lords, I then turn to the December 2014 committee meeting, and for this I need to go to the appendix, part 2, tab.
In the meantime, there'd been a reference to the Secretary of State had considered whether to call it in and had decided not to, although the departmental caseworker thought it ought to be called in.
That's correct, my lord. The recommendation to the Minister was that it should be called in, Minister decided that it shouldn't be called in.
And there's no challenge to the Secretary of State's decision on that?
No, at one stage the CPRE indicated that they would consider challenging that, but didn't do so, and one might think that was a sensible decision in that it's proved very difficult to bring challenges to decisions not to call in applications.
Right.
So turning to December 2014, so this is tab 3 in the appendix part 2 and begins at page 575. The application was returned for consideration by members, and one of the purposes of returning this application for consideration by members was that a planning obligation had been agreed, and the terms of the planning obligation are set out in this report. And they're set out in some detail from paragraph 12 of the report onwards. The important point that I should first make is that on this report there is a recommendation on page 575 on the front of the report, which was a recommendation that having regard to the committee resolution to grant planning permission and taking into account the matters set out in the report, including the material considerations that have emerged since the application was previously reported, that conditional planning permission be granted. So it was positive, but it's right that I point out that the terms of that resolution were the recommendation that was made were changed, and if the court goes to 621, you can see the resolution that was passed, but that was the resolution that was put before members for their consideration.
Mr. Cameron, I'm slightly struggling with your numbering.
Yes, I apologise, my lord.
There are so many numbers.
Well,
But, I mean, looking at the 18th December 2014 first page, we've got a 244. I know you're counselling us to ignore those numbers. Then I've got an AB 516.
and I think, my lord, you've got a P325 on the left as well. But I was trying to take the court to the electronic numbering.
I don't think I've got it.
Well,
So can you give us at least
Yes.
one other number?
my lord, yes. Can I try with...
So,
Can I make a bid for P325?
Which bundle are we in?
We're in the appendix part 2.
Now, are we looking at the front sheet or are we looking at the resolution?
We start with the
I've
front.
got the resolution on page 621. Also page 523. Also page P371.
My lady,
Also obscured page AB-562.
yes, my lady, yes. That is the resolution that was passed. The recommendation that was made the recommendation that was initially made is at page P325 in the paper copy. That resolution appeared on the report, but the actual recommendation made by officers is at page P366, which I think in the electronic copy is 616. P366 in the paper copy is the recommendation put by officers.
thank you.
And why does it matter what the difference is?
Because the second line, having regard to the committee resolution and subject to the committee being satisfied. So that's why it matters, my lord. And can I just draw the court's attention to page P356, 606 in the electronic copy, where there is the officers address the question of paragraph 116, the National Planning Policy Framework. And can I ask the court to read 144, please?
Sorry, 144.
Of the report, my lady.
Paragraph 1.
Paragraph 144, P356,
Electronically.
606, my lady.
Thank you. Finely balanced exceptional justification.
My lady, yes. And at 145, there's a reference to exceptional circumstances, which are those are the words found in paragraph 116 of the National Planning Policy Framework. The reference that I made in answer to Lord Lloyd Jones was to the section 106, which is a reference to the planning obligation, which is under the, comes in the last sentence of paragraph 144. So,
Was there any reference in this report to the duty to give reasons under the EIA regulations?
no, my lord.
Or anywhere else?
No. So in paragraph 162 on page P361 and 611 electronically, and this is, in my submission, important. In the context of the previous committee resolution to approve the application, subject to members continuing to be satisfied the proposals accord with the requirements of the National Planning Policy Framework, recommendation set out above is the application be approved on the basis that the material considerations outweigh the indication given by the development plan. So the recommendation at this stage was for approval, and that I place significant emphasis on. The members, taking this as quickly as I can, rather conscious of the time, is if one goes to the resolution at page P371, electronic 621, and before it was moved and duly seconded by Councillor B.W. Butcher, the application be approved as per the amended officer recommendation circulated at the meeting, which is why I referred to the change to the resolution. And then the recommendation was carried. This is, I have to accept, slightly curious because the resolution was in the terms of the recommendation and included the words subject to the committee being satisfied. And by the fact that they passed the resolution, I submit they must have been taken to have been so satisfied, otherwise they wouldn't have passed the resolution. So that, my lady, those are the facts.
Yes, and you've got about 7 minutes left.
Yes, my lady. Mr. Reid is indicating, I think, that I can trespass partly into his time, but I don't want to trespass very much into it.
Well, it's entirely up between you. You have a total amount of time available and you can divide it up as you wish. But we're interested in the law.
Yes, lady. So if I turn to the law, first of all, and I take this from the statement, the issues in the statement of facts and issues. The first question, is there a common law duty to give reasons?
Would it be better in the time available to concentrate on the second group of questions, given there's an admitted duty under the EIA? Where does one stand on that?
Lord, yes.
I mean, the common law duty is we ask for information, and it's all been very helpfully set out, and it's a fairly sort of messy picture, but if there's a clear EIA duty which you fail to comply with, then the only real issue as far as you're concerned is really what the remedy is.
Well, my Lord, yes, I can turn to that, but if I can, there is, on the common law duty, if I can take it very quickly, it's my submission that there's no general common law duty to give reasons when granting planning permission, and I rely on Chaplin. Can a duty to give reasons be implied by the common law? Yes, I accept it. Can. The essential test from Doody, and the references are in the various cases put before the court, is fairness. The real issue for the court is, can or should the court formulate a test to be applied for planning applications to determine whether a duty arises in a particular case. The position of the second appellant states that the duty arises when it is aberrant, the decision is aberrant. The CPRE, the respondent, appears to argue that the duty arises when representations are made and in effect require answering. The position I adopt on behalf of Dover is that the courts have found it very difficult to define a precise test to be applied. That was the issue that arose in Oakley. The Court of Appeal stood back from taking a view that a general test should be applied, the broad approach, and made a decision turning on the facts. The facts in Oakley were very different because there were no reasons at all that could be discerned. And I would invite the court to adopt the approach taken by Mrs. Justice Lang in Hawksworth at paragraphs 80 and 81, and that to hold that the duty would only arise exceptionally in order to meet the requirements of fairness.
But I mean, if that is the test, it's difficult to imagine a stronger case than a major, highly controversial application in the AONB, where they're departing from a very closely reasoned report of and recommendation of their own officers, and where there are very strong objections. I mean, if that's a test, I'm not sure we should be defining a test, but I find it difficult to see how this doesn't fit, if that is the test.
Well, but, my Lord, if that is the test, the real issue in this case, certainly as far as the District Council is concerned and the way that it's been argued in the courts below, is that the reasoning was sufficient, not that the...
Yes, I mean, your position is there is adequate reasoning here to be found in the report and the minutes, and it's mere formalism to require you to put that in a note. And that applies whether we're talking about the EIA or some general common law case. So probably best if we look at that rather than worrying
Certainly, my Lord.
Speaking for myself.
We've addressed it in our written submissions because the court asked us to do so. So
Yes,
we've done
no,
it.
it's very helpful, and certainly it took me down memory lane.
Well, maybe that I will take Lordship in the short time available down memory lane.
The rest of us are on a voyage of discovery.
So, Lord, the adequacy of the reasons is the crux of the issue between the parties, certainly as far as the District Council is concerned. Because it's my submission that the reasons can be discerned from the officer's report and the minutes and the second officer's report, which I've just taken the court to, December 2014. But
I mean, you're not, as I understand it, going along with Mr. Reid to say that the EIA duty is somehow less demanding than a common law duty would be. I mean, you're content to apply Lord Brown's summation in the South Bucks case?
No, my Lord. The submission that I make is that sets too high a standard for members when deciding issues in the context of a planning committee, and I do adopt the reasoning of Mrs.
This is Hawksworth, I see.
Hawksworth, and that is the position that the District Council took in the Court of Appeal.
Okay.
And so, my Lord, given the time, can I go straight to Hawksworth, which is in the Authorities Bundle 1, tab 26. And so now I'm going to hope, so it's tab 26, and in the judgment, it's paragraphs 80 and 81, but on this issue, 87. I will go straight to 87. I'm afraid on page numbers, there are two different page numbers. I don't know which is most helpful, but 1349, which might help in the electronic version. And paragraph 87, I rely on, and the argument that was described by Lord Justice Laws in the Court of Appeal as a plea to administrative convenience, and he said that some might say that the cynic would describe it as such, as a description of my submissions in the Court of Appeal. But the submission that I do make is that the test for reasons set out by Lord Brown in South Bucks and Porter was dealing with a decision made by the Secretary of State on a planning appeal. And the Secretary of State on a planning appeal has the benefit of an inspector's report. The inspector either deals with it by written representations or a hearing or an inquiry, but whichever method is taken, adopted, it is an action between parties. You've got the local planning authority and the developer who put opposing cases. And because they put opposing cases, there is what Mrs. Justice Lang described as an adversarial procedure. And if there's an adversarial procedure, there are different points taken by each party, and one would expect a finding on those points.
But here we're dealing with the view taken by their own officers and their recommendation. I'm not sure that this helps very much.
Well,
I mean, surely if you want to have reasons of any sort, they've got to deal with the principal controversial issue, haven't they?
well, my Lord, they do have to deal with issues that require resolution.
Yeah.
I accept that. But it is a very different forum to a planning appeal, and it is my essential submission that it would be wrong to impose on members of a local authority and an unduly onerous duty to set out and to make findings on each dispute of fact. If they had to do that, they would have to set out.
I don't think anyone's suggesting that, are they? I mean, this is in the context of the now repealed requirement for a summary of reasons, isn't it? So one's got to bear that in mind. So whatever common law duty we're talking about, or EIO duty, may not be simply a summary. But I mean, here we're simply talking about how they concluded on the principal controversial issue, which is whether, as their officer suggested, there should be moderation and whether that would work.
Well,
you say they've done enough to explain that, but that's the issue, isn't it?
But before I get to that, one gets the question of how much do they have to do? And
explain what they thought.
Well,
that's what reasons are.
Well, that's exactly what they did do. And they grappled with the essential point because it was put before them that when the officers, and I don't go back to the report, made the recommendation reduce it from 521 to 365, the essential part of their argument was, and this won't jeopardise the scheme. It'll still be viable, it can still go ahead. The applicant then puts forward the argument from BNP Paribas saying it would be at risk. And it's clear that the members made their decision based upon not putting the scheme at risk, and that they did so in the context of seeking to moderate harm. But, my Lord, I do go back. South Buckinghamshire and Porter was not dealing with the summary of reasons which was required under the previous statutory instrument for decisions of local authorities. It was dealing with an appeal to the Secretary of State and all the detailed analysis and the adversarial process that involves. And that's completely different to a local authority, members sitting there. And if one were to impose a similar duty on members, it would make it extremely difficult for them to take views contrary to the recommendation made by their officers, because they would have to sit there in their committee and set out each issue of fact that was in dispute and set out their position. And in my submission here, the position is, the approach was adequate, first because they grappled with the essential issue, which was the, would it put the scheme in jeopardy? That's in the minutes. It's then the December officers' report reminds them of that and sets out how, if they wish to, they can grant permission, and they accepted that formulation put forward by officers. So one can then look back and to the arguments and to the analysis set out in the December report. So I don't rely entirely on the minutes, the June 2013 minutes. I rely on the June 2013 minutes and the December 2014 report.
Well, you've already pointed out the December report is ambiguous in that the resolution says subject to, but you're saying that that means that the councillors who passed that resolution nevertheless were satisfied that that condition had been fulfilled.
Well, my lady, yes, otherwise they couldn't have passed the resolution to grant.
Well, it's a bit weird, isn't it? No.
Well, I have to accept it's not as clear as it might be, but
I suppose you can pray and aid the fact that there's been a duty to give reasons for refusal ever since time immemorial, and that's always been satisfied by a relatively short statement without going into the sort of detail that the Secretary of State would go into.
it has been satisfied, and actually that requirement in the Development Management Procedure Order is to give a full statement, and it's satisfied by the reasons which one will find, which will probably be a paragraph for each reason.
Well, we're really talking about the situations in which the councillors disagree with their officers, aren't we?
Yes.
For practical purposes, yes. Because usually the officers' reports are pretty fully reasoned, and you can simply say, well, the officers gave a tick. I mean, the councillors gave a tick. The real problem is the cases in which the councillors disagree, either way.
Lady, yes. But of course, the members are there to make their decisions.
Absolutely.
Yeah. I would urge the court not to place too high a hurdle in the way of members when they decide that they don't want to follow their officer's advice. I mean, here it is slightly different because on the first occasion they didn't follow their officer's advice, but on the second occasion in December they were given a way forward which they then accepted.
Well, their officers had loyally accepted their previous decision, as one would expect.
They had, my lady, but to be fair to the officers, they also made plain that their views hadn't changed, but they'd accepted the views taken by members. Can I just, in the few moments left...
Well, you're well over your time,
Well,
and Mr. Reid has only got until 25 to 1, whenever you stop.
Bite into his reply.
Well, you could bite into your reply, but that's entirely, again, a matter for you.
My lady, what I would wish to do is to respond to Lord Carnworth's points on discretion, and I will do it very quickly. What I'd like to draw the court's attention to is bundle 4 of the authorities bundle, tab 5, and to judgment of Mr. Justice Lindblom, as he then was in the West Kensington case. And I'd rely upon, so it's tab 5, authorities bundle 4, and the only page, I've only got one set of page numbers, 134, but I place particular reliance
134.
134, my lady.
Could possibly be 134.
Oh, well, it's paragraphs 204 to 208 in the judgment of Mr. Justice Lindblom in West Kensington. And in that judgment, the judge was dealing with a failure under the Strategic Environmental Assessment Directive to set out a statement, and he relied upon the Court of Appeal's approach in the Richardson case, on which I rely in this case, and that is at 207, refers to Richardson, and I draw particular and place particular emphasis on 208, where the judge says the same essential reasoning, now strengthened by the Supreme Court's decision in Walton, applies in this case too. So and without taking the court to it, I rely on Walton, which is in the same bundle of authorities.
I really must insist on an electronic page reference, please.
My lady, yes. Well, I'm told, and I'm ready to take the far, that we only have a paper copy of the authorities in bundle 4, and there is no electronic version. So
And I don't have bundle 4 in paper either.
Well, I apologise, my lady.
I expect that's not your fault.
Well, I'll take the blame for it.
It's almost certainly never your fault.
Well,
Yes.
I'm
Well
prepared
be mine.
it probably is. I'm prepared to take the blame for it.
But
But this is not acceptable. You ought to supply all your authorities electronically, properly indexed. There isn't even an index to authorities electronically, properly cross-referenceable, and you're putting everybody in a difficult position. These are totally predictable authorities that you might want to refer to, aren't they? They're not exactly off-the-wall things that somebody doing a really delicate search. So why is this not electronic?
My lady, they went in...
It's not your fault, it'll be others miles away from you.
No, I'm perfectly happy to say that I should have checked, but it went in late, and I'm told that we were told that we couldn't upload it electronically, but that's what I've been told But whether that's right or wrong, I don't know. But
If I could just observe that I'm slightly surprised by being referred to a decision from Mr. Justice Lindblom, eminent though he is, in the first instance, for the effect of, I mean, the critical thing is the decision of the Court of Appeal in Richardson, where they seem to have said that there was something distinct about EIA reasons, which meant that they didn't have the same consequences as common law reasons. But since then we've had, he refers to our judgment in Walton, which is a judgment of this court, and then subsequently there's been a judgment in a case involving Dr. Campion, was it? But
Champion.
Champion. I'm not quite sure why we aren't being referred to decisions of that level, and why we're having to look at them through the prism of Mr. Justice Lindblom.
My Lord, I was only referring to that because
can I just say where
yes.
just because we haven't got much time, I would require some persuasion that the consequence of a failure of the EIA reasons duty is different from a failure of any other duty. I mean, it's a question of prejudice. We've dealt with that in the EIA context in Champion, but I need some persuasion that there's some difference of approach.
Well,
I don't think that Mr. Justice Lindblom is going to persuade me.
no, my Lord, I'm not relying on Mr. Justice Lindblom in that respect. I drew attention to this case because it deals with a European directive and it refers to the fact that the position in Richardson has been strengthened since Walton.
Yes, but this was strategic environmental assessment, which is completely different.
Well, it was, my Lord, but a statement of compliance was required. And the essence of my point, if I can put it, is that the reasoning provided was adequate. It would have been adequate for the purposes of the duty to state reasons imposed by the EIA directive. The EIA directive requires that the statement be produced when the decision has been taken. So it's after the decision has been taken, and that the appropriate remedy where the reasons were adequate, if you find the reasons weren't adequate, then I accept I'm in difficulties. But if the reasons were adequate, then the appropriate remedy is to order that the statement be produced.
But I mean, that's only if you can see from what you've got what the reasons were. Well, your case is you can. Well, if you're right on that, you win. But the other side says they're not. So,
my Lord,
in a sense, we're arguing about something which doesn't. I mean, it comes back to a very simple issue. I mean, not a simple issue, but quite a short issue. Is there enough in the documents we've looked at to explain what your reasons were?
Well, my Lord, yes, and that's why I took a little bit of time on the facts.
Yeah, well, I think right to say. Thank you.
My Lord, I will sit down now, but I do rely on Walton and Champion. I apologise for going over the time.
Mr. Simons, I suppose I'm right in assuming that you don't wish to follow your leader.
Well,
Mr. Reid.
My ladies, my lords. Can I deal firstly with the question of the bundle? I apologise on our behalf as well. However, we were told by the registry, I'm told, not to upload bundle 4 electronically, but to send PDFs through to the registry. So it sounds as though there may have been a confusion that arose within some parts of the relevant offices. My lady, can I deal in brief with the submissions that I propose to make, to set them out, and then I'll, with the time available to me, try to deal with some of the aspects of the case that I say are most important. The first issue I'll deal with is the EIA duty. I'll touch firstly on the standard of reasons, because I say that they are important for understanding the degree to which the relevant rights under European law have been enjoyed, and so the extent to which relief should be granted in this case. I'll deal with certain aspects relating to the standard of reasons, including the fact that additional information can be provided by the decision maker, and the extent of the reasons, the degree to which the reasons are acceptable, will be judged according to that additional information as well, and also touch on the extent of the use of minutes. In simple terms, I say that minutes can be used to explain a decision under European law. I'll also go on to deal with some aspects relating to relief, but I accept what my Lord Carnworth says with regard to the extent to which one should be looking for guidance in Champion. I say that Champion does provide the proper guidance because it sets out the need to establish that the rights in question have been enjoyed by the person relying on those rights, and in truth whether there has been any substantial prejudice. And I say in this case that there is no substantial prejudice for reasons that have been set out by Mr. Cameron. On the common law, I'll deal with the question of the existence of the duty. I say there is no general duty that is imposed, or should be imposed by the court, to give reasons when a council grants planning permission. There have to be some special circumstances, we say, and those circumstances, when properly understood, can only be if they are to be properly principled on the basis that the decision in question appears aberrant. And I'll come on to why that's the case shortly. As to the standards, the standard of reasons under the common law, I support the position taken by Mr. Cameron, namely that summary reasons are sufficient in the circumstances. So,
how can you know whether or not a decision is aberrant if you don't know what the reasons for it were?
well, my lady, when a set of reasons, when a decision has been reached in a planning context, of course, there's the officer's report and minutes. It's possible then, if one's looking at it from the perspective of officers, possible for officers to reach a judgment as to whether actually there needs to be further reasoning given in order to properly explain it. So on a practical basis, it's then possible to judge whether there's a possible aberrance in the decision itself that needs to be plugged by way of further reasons. But when it also when the issue comes to the court, and if there's a challenge and there's a judgment that has to be reached by the judge as to whether the reasons are sufficient, the judge, of course, is able to reach a conclusion as to the degree to which the decision is, on the face of it, aberrant. And of course, when one's looking as to what aberrance is in the circumstance, or what is aberrant, rather, one will judge that according to the usual public law principles. So I say that it's clear to the degree to which a decision in question appears aberrant by virtue of its nature. So,
can I just pick you up on the question of whether they need to be more than summary reasons? And this is a point you make at paragraph 54 of your printed case by reference to a case called Chirkley, which you also refer to at paragraph 31. But as I understand it, and it's clear from the reference there, that rested on a concession of counsel.
yes.
That the reasons, the duty under the EIA wasn't any greater than the duty to give summary reasons as it then was under the development order.
Yes, I accept that.
But, I mean, I would, again, as I think I made clear, I need some persuasion that that is a proper way of looking at it.
Well, my Lord, with regard to the nature of reasons, I align myself with Mr. Cameron's submissions. I say that the extent of administrative difficulty that arises from the requirement to give detailed reasons in circumstances where a decision has been reached contrary to officer recommendation would, at least if one was following the approach taken by Mr. Howell, require considerably detailed reasons, something akin to another officer's report in detail, in order to fulfil the requirements that, if one was applying Porter or Mr. Howell's formulation, would apply. So I said that there is a fundamental administrative inconvenience associated with the duty to give detailed reasons. Of course, there may be a different position with regard to the EIA requirement, but in the circumstances, I say that in any event, it's been fulfilled here by virtue of the reasons that have been given. And my Lord, just to deal with the requirement to give summary reasons, that point has been canvassed before Mrs. Justice Lang in a Hawksworth case, and the reasoning that she has applied and that my Lord has seen, I say, is the correct approach to take. But going back to the question of the EIA duty, can I deal firstly with the extent to which it's possible to rely upon information already held by the applicant when reaching a conclusion as to whether or not the duty has been satisfied? And if my Lords go, and I apologise for asking my Lords to do so, but go to the authorities bundle 4, and forgive me, my Lords, it's in fact it's in a different bundle, the supplementary papers bundle. Now, my lady, this is a bundle that's been prepared by the respondent, and
What are we looking for here?
it's
Supplementary papers.
a supplementary papers bundle.
And we do have that electronically.
That is a separate.
Yeah, it's a separate document.
In that case, my lady, the relevant page number, Melina Junior will perhaps be able to get me the electronic number.
What do we actually
There are
look
two European cases
Tab.
and some aerial photos.
Yes, my lady, and it's the tab 1, the Evra-Pikey
Dyke
case. Yes, my lady. My lady will see, if my lady turns to paragraph 109,
On what page?
page 22 of the internal bundle.
Sorry, paragraph?
109, my lady.
That's not on page 22. Well, it is actually on page 22 as printed. It's on page 24 on the electronic bundle.
Paragraph 109, though, relying on the Strabag case, which is also within the authorities bundle, makes clear that the duty to state reasons must be assessed in the light of the information available to the applicant at the time the application was brought. Now, if one then goes, in order to understand that statement, to the Strabag case, which is in the authorities bundle 3, electronic pagination 2147, and at tab 58 and paragraph 58,
Sorry, which tab was that?
tab 58.
Thank you. Step back.
My lords will see, and my ladies will see, that it said that in any event, in contrary to what the applicant claims, the duty to state reasons must be assessed in the light of the information available to the applicant at the time when the action was brought. And then it goes on to deal with the particular requirements of the directive. But, and this was a case relating to particular tender requirements under European law, but nevertheless, the ability to satisfy the duty to give reasons by virtue of the information held by the applicant at the time that one is considering the duty is something that I say is of importance in this case.
I mean, that's dealing with a case where it's the applicant who has a particular commercial interest in what's going on. not a sort of public case like this where the whole community has an interest. So I'm not sure how it helps.
Well, my lord, it helps insofar as the duty that's contained within the EIA regulations is a duty that is being relied upon in this case by a particular applicant, and that applicant had the relevant information contained both in the relevant officers' reports and the minutes available to them by way of the documents that are held on the web. So it is important.
Yes, I mean, that's not in dispute. The question is whether that was good enough to satisfy the duty, isn't it?
No.
Quite, my lord. But in terms of the degree to which one can rely upon that information for the purposes of satisfying the EIA duty, I say that it indicates that one can rely upon that extrinsic information in order to satisfy the duty in question. Because, of course, I say that the duty can be satisfied in this case by virtue of a simple statement that refers to the officers' reports and the minutes. In short, one can understand, for the reasons that Mr. Cameron set out, why it is that the decision has been reached.
Mr. Reid, I'm sorry to bother you, but you're already 5 minutes over the time allotted by agreement between the parties to the appellants. That time obviously comes off your combined time for reply. So it's entirely up to you how long you go on for, subject, of course, to your not taking up the whole of your time for reply.
Right, my lady. My lady, in that case, can I very briefly deal with a few additional matters? Firstly, the reliance on minutes, as we do in this case. There has been a suggestion by my own friend Mr. Howell that there are difficulties with relying on minutes. And I accept that there may be difficulties in relying on minutes in certain cases. But in this case, the minutes can be relied upon for two reasons. First, that there's no case that says in principle minutes can't be relied upon. And second, because the minutes, particularly the June minutes, are referred to specifically within the December officers' report. They were appended to the December officers' report, and so were capable of being understood by virtue of what was then subsequently said in the December officers' report. As to the question of the common law duty, my lady, and I don't propose to deal with the existence of the duty. That's already been dealt with by Mr. Cameron. I say that there is no general duty. There is, however, a specific duty, and that specific duty can be identified as a matter of principle in a case that has been referred to, in fact, by Mr. Howell in support of his case, but I say that supports my case. It's the Higher Education Funding Council case, which can be found in the first bundle of authorities. Tab 27. Electronic pagination 1373. And the bundle, main bundle reference is page 436, where Mr. Justice Sedley, as he then was, set out in summary the classes of cases in which there is a duty to give reasons. And he identified two classes. One where the class is of such importance that fairness requires the giving of reasons, and the other is a class of case where the decision appears aberrant. And he identified those as being two essentially closed cases which would cover the basis upon which one would impose a duty to give reasons. As to the first of those, it's clear that looking at the cases relied upon by the court in the Higher Education Funding Council case, particularly ex parte duty, and also cases that looked at this subsequently, the Matson case relied upon by Mr. Howell, that these are cases of particular importance to the individual, the recipient of a decision that would have direct effects on them by virtue of that decision. And I say that this case does not fall within that class. In fact, this case, on Mr. Howell's argument, falls within a general class of fairness, on his analysis, fairness, where simply because a decision has been issued that may affect someone, they should be entitled to know the basis of the reasoning in order to understand whether they should go to law. Well, that is the same, I say, as imposing a general duty to give reasons. The only principal basis must be one that is capable of being understood both at a practical level and in the courts. And I say that Mr. Justice Sedley's analysis in the Funding Council case provides the proper basis. And so, since the first class is not one that applies here, I say it can only be in the second class of case, and that's where the decision appears aberrant. One point of fact, if I may deal with it finally, and it concerns the point relied upon by Mr. Howell and raised by my Lord Carnworth, and it arises in respect of something said in the officer's report. So if ladies and lords could go please to Core Bundle 2, and this is the officer's report for June, Core Bundle 2, and page 448 of the electronic bundle, paragraph 2.217. And my Lord Carnworth asked whether or not the drop from Code 4 to Code 3 had been assessed by BNP Paribas. And in relation to the significance of this point, whilst on the face of it, the committee weren't referred to the effect of dropping from Code 4 to Code 3, nevertheless, the significance of the drop from Code 4 to Code 3 was one where there would be less sustainability associated with the development in question. And sustainability was one of the important factors that was taken into account for the purposes of understanding whether or not there were exceptional circumstances here. So if the code level dropped, it would have an impact on sustainability. And that was a part of the reasoning, ultimately, that it persuaded the members to reach the conclusion.
Sorry, where do we find that? I mean, the question was whether BNP Paribas addressed it, and the answer, I think, is no.
With regard to the analysis, there was nothing before the committee that indicated the effect in financial terms of a drop from 4 to 3. But the significance of dropping from 4 to 3 was also then that it would have an effect on...
Yes, but I mean, are you saying that that was addressed somewhere as being an issue of sustainability?
My Lord, yes, I do. If my Lord goes to page 2450 in the officer's report, that's page 485 of the bundle, electronic reference, page reference 491. Under the heading, just actually on the page before, sustainability appraisal and overall planning balance, (2450), the last part of that, account has also been taken of the potential to secure important environmental improvements, and one can see there the energy efficiency measures in the new development through Code 3, and that was a drop. That was taking into account the drop from Code 4 to 3 in accordance with the officer's recommendations, but nevertheless showed the importance of the code to the impact of sustainability. And if ladies and lords, go to then 2457. There's a reference there to the committee reviewing the economic, housing delivery, heritage and other benefits associated with the development. And so it was one of the factors that was then taken into account, code levels, for the purposes of reaching a conclusion as to whether or not there were benefits associated with the development, such as to amount to exceptional circumstances in the case. So that's how I say it needs to be read. So that irrespective of the fact that it wasn't dealt with in financial terms, there was a reason for concluding that it didn't make a difference to the members' conclusions. I won't say anything more in the light of my lady's indications, for which I'm grateful. I shall leave what I have for reply at the appropriate time.
Thank you, Mr. Reid. Mr. Fraser? Well, by my calculations, you've gone a quarter of an hour over time. I hope that accords with Mr. Howell's calculations. That means that you have a quarter of an hour less for your reply.
My ladies, my lord, I propose to deal firstly with what a statement under the EIA regulations must contain. Secondly, what the normal consequence of a failure to provide it is. And then thirdly, whether, as a matter of discretion, the planning permission in this case should not be quashed. If I have time, I'll deal with more general issues about common law, but I'm going to focus on the EIA because there's an express statutory duty in this case. Although my learned friends have sought to draw a distinction between the Secretary of State and local planning authorities, for the purpose of the statement, they're both under the same obligation to provide the self-same statement in the regulations. Your Lordships haven't been shown that. It's in Volume 1, Tab 11, at page 1094 in the electronic bundles. The relevant obligation for the local planning authority is in Regulation 24(1) which is to make available for public inspection to place where the appropriate register or section of the register is kept a statement containing the content of the decision, the conditions, the main reasons and considerations on which the decision is based, and if relevant information about public participation, a description where necessary of the main measures to avoid, reduce and if possible offset major adverse effects of the development, and information regarding the right to challenge the validity of the decision, the procedures for doing so. So for, under the CPR, that's now 6 weeks. In the case of a local authority decision. So far as the Secretary of State is concerned, under paragraph 2, where an EIA application is determined by the Secretary of State or an inspector, the Secretary of State shall notify the relevant planning authority and provide the authority with such a statement as is mentioned in subparagraph 1C, and then they have to deal with it in the same way by making it available to the public. So,
does that replicate something in the relevant directive?
I was going to show your Lordship the directive. And it's important in my submission to bear in mind that this is intended to implement Article 9 of the relevant directive and also Article 6 of the Our House Convention. If your Lordships will go firstly to the directive, which you'll find at tab 17. And electronic bundle, page 1135. Your Lordships, the Article 9 provides that where a decision to grant or refuse development consent has been taken, the competent authority or authorities shall inform the public thereof in accordance with the appropriate procedures and make available to the public the following information. The content of the decision and any conditions attached thereto. Having examined the contents and opinions expressed by the public concerned, the main reasons and considerations on which the decision is based, including information about the public participation process, and then the point about mitigation. And under subparagraph 2, the second subparagraph, you have to do it in an appropriate manner, so that's how it's been provided there. That was intended to give effect to the Our House Convention provisions. You'll find those at the next tab. I know my Lord Carnwath is very familiar with the convention, but it is perhaps worth noting the background which is being recognised on 1152 of the electronic bundle pages. If I can just note the background, about 1, 2, 3, 4, 5, 6, seventh recognition, if I can put it that way, where it says recognising also that every person has the right to live in an environment adequate to his or her health and well-being, and the duty both individually and in association with others to protect and improve the environment for the benefit of present and future generations. And considering to be able to assert this right and observe this duty, citizens must have access to information, be entitled to participate in decision-making, and have access to justice in environmental matters. And one can see the objective of the Convention is reflected in Article 1 on page 1153, including both participation and access to justice, both of which are significant. If one goes to electronic bundle, page 1159, one comes to Article 6, which is dealing with public participation in decisions on specific activities. And again, if I can take it very shortly, the relevant provision about reasons, if I can put it that way, if one could go to page 1161, if one can just note firstly, paragraph 8 of Article 6, each party shall ensure that in the decision due account is taken of the outcome of public participation. Each party shall ensure that when the decision has been taken by the public authority, the public is informed of the decision in accordance with appropriate procedures. Each party shall make accessible to the public the text of the decision, along with the reasons and considerations on which the decision is based. Now, your Lordships will note that there is a slight difference in wording between this article of the Convention and the article in the directive. The article in the directive refers to the main reasons and considerations. This refers to reasons and considerations. And in my submission, the directive forced to be construed to give effect to the Convention for two reasons. One is that secondary legislation of the community forced to be interpreted in accordance with its general international obligations. And can I give you a reference to the general position, one in respect to the specific convention? The general matter is in volume 3, tab 57, page 2144 at paragraph 16. That's the Rienzi case, where they say this is law. My Lords, if your Lordships want to look at it, I'll just take it quickly. It's paragraph 16 on page 2144. As regards the influence of an international agreement to which the communities of parties such as GATT is capable of having on a provision of secondary law, it's settled case law that the primacy of international agreements concluded by the community over secondary community legislation requires that the latter be interpreted so far as possible in conformity with those agreements. And that was applied in the case of the Aarhus Convention in tab 51 at page 1891. This was a case about the Aarhus Convention dealing with the aspect about access to environmental information.
What's the name of this case?
This one, at tab 51, is the Association of Justice and Environment against the Commission. It begins at page 1879, my Lord.
And the paragraph number is?
And paragraph number is 77 for present purposes.
Thank you.
On page 1891, and it applies it in relation to the convention.
Yes.
There is also a further reason why one has to construe the directive in accordance with the convention, precisely because the directive was amended to make it fully compatible, so the community thought, with the directive, with the convention. If I can just show you all briefly that's tab 16 in volume 1 at page 1122. This is Directive 2003-35 EC, which made the amendment. Can I draw your attention firstly to recital 5, which says the community signed the convention and the community law should be properly aligned with the convention with a view to ratification by the community. And then if you could briefly note, recital 7 refers back to Article 6 of the Aarhus Convention, And recital 9 is Article 9.2, which deals with access to justice provision. If you go over the page to recital 11, Council Directive 85337, that's the EIA directive, page 1123, on the assessment of effects of certain public and private projects on the environment, and Council Directive 9661 concerning integrated pollution prevention control should be amended to ensure they are fully compatible with the provisions of the Our House Convention, in particular Article 6 and Article 9.2 and 4 thereof.
And Article 6 is referred to also in the 2011 directive preamble.
It is well, as well. But I showed your Lordship that's when the relevant wording of the directive was amended to make sure it's fully compatible. My Lord, what I was then going to go on to do, I don't know if this is a convenient moment, was to deal with what EU law requires in order to satisfy an obligation to give reasons, and then show you that in general, and then show your Lordship that Article 9 serves that purpose as well.
That sounds like a very convenient moment at which to pause. We'll look forward to hearing from you further at 2 o'clock, and the court is now adjourned.